Good morning, this is your Kelso Report for Monday, August 29th, and I'm your host, Clark Kelso. Well, a little over a decade ago, the California legislature enacted the Mental Health Parity Act. Its inspiration was the observation that health insurers generally covered medically necessary treatment for physical illnesses to a much greater extent than medically necessary treatment for serious mental disease. The Mental Health Parity Act was intended to level that playing field somewhat. The Ninth Circuit applied the act in Harlech v. Blue Shield of California, where the issue was whether the insurer was required to pay for the insured's cost of care at a residential treatment facility to treat her serious condition of anorexia nervosa. The first question for the court was whether the costs of treatment at the residential treatment facility were directly covered by the insurance policy. For mental illnesses, the plan covered inpatient services, limited outpatient services, office visits, psychological testing, and in-person or telephone counseling sessions. But the plan expressly provided that, quote, residential care is not covered, close quote, although it did not define the term residential care. The insured tried to argue that the facility at which she was placed at was actually a skilled nursing facility, otherwise known as a SNF, the costs of which would be covered under the plan. The court rejected this argument because skilled nursing facilities is a fairly well-defined term in the healthcare industry, and skilled nursing facilities are licensed as such by states. The facility the insured was at did not have registered nurses and was not licensed as a SNF. And even though the plan did not define residential care, that term has broad usage in the healthcare industry, and the facility at which the insured was being treated identified itself as a residential treatment facility. So the court held the costs were not covered by the plan itself. However, the court ultimately concluded that the costs were covered by virtue of the Mental Health Parity Act. The act requires that a plan which provides medical coverage, quote, shall provide coverage for the diagnosis and medically necessary treatment of severe mental illnesses under the same terms and conditions applied to other medical conditions, close quote, with respect to plan benefits such as co-payments, deductibles and limits on maximum lifetime benefits, and other features. Several mental illnesses, severe mental illnesses, include schizophrenia, schizoaffective disorder, bipolar disorder, major depressive disorders, panic disorder, obsessive compulsive disorder, pervasive developmental disorder or autism, bulimia nervosa, and anorexia nervosa. Given these statutory mandates, the question would have been whether the treatment at the residential care center was medically necessary in the circumstances. The facts show that the insured's doctors believed outpatient treatment was insufficient, and the insured entered the residential facility at 65% of her ideal body weight, and she needed a feeding tube while at that facility. Ultimately, the court did not have to address the precise question because the plan had never really asserted that her treatment at the facility was not medically necessary. Instead, the plan had argued it was not legally obligated to cover care at that facility. Given that the court found against the plan on that point, the panel held she was entitled to coverage. The result is that even though the insured's plan had an exclusion for payment for residential care, pursuant to the California Mental Health Parity Act, such coverage was required as a matter of law because it was medically necessary. And now our one-liners. We start out with the criminal procedure case. In SEC versus Gewerter, the Ninth Circuit held that a Nevada federal district court did not have authority to quash a subpoena issued by a California federal district court. Pursuant to a 1991 amendment, Federal Rule of Civil Procedure 45 C3A provided that a motion to quash or modify a subpoena should be decided by, quote, the court by which a subpoena was issued, close quote. The current language even more clearly provides that a motion to quash or modify should be adjudicated by, quote, the issuing court, close quote. As a result, the court that issued the subpoena, and not the court where the underlying action was pending, was the only court which could entertain the motion to quash or modify. Another qualified immunity case. We've had quite a few of these in the last week or so. This time in Young versus County of Los Angeles. The Ninth Circuit held that a police officer used excessive and unreasonable force in the context of an ordinary traffic stop for a minor infraction, where the suspect clearly posed no threat to the officer or public safety. The plaintiff had been pulled over for a seatbelt violation. He also was missing a side mirror and a rear license plate. When he couldn't find his vehicle registration, the officer ordered him to continue searching, while the officer returned to his motorcycle to begin writing a citation. The plaintiff found the registration, got out of his truck, and gave it to the officer. The officer then ordered him to just have a seat in the truck. Well, the plaintiff refused, stating, "I don't feel like sitting in my truck." And instead, he walked past his truck and sat on the sidewalk curb and began eating a piece of broccoli. Well, the officer repeated the order, and the defendant again refused. And you can guess what happened next. The officer came up behind the plaintiff while the plaintiff was still seated on the curb and began to pepper spray him. The plaintiff stood up and tried to back away. At that time, ostensibly worried that the plaintiff was trying to get a better position on him, the officer struck him with his baton several times. The plaintiff finally dropped to the ground to avoid further injury. On these facts, the Ninth Circuit held the police officer lost his qualified immunity and was subject to a suit for damages liability. And to add insult to injury, it turned out that the plaintiff was a probation officer. Next, a juvenile law case. In In re Miguel C., the First District affirmed the juvenile court's determination to remove a 6-month-old child from his mother, who suffered from mental health and drug abuse problems, and whose 3 older children were already not in her care, and then to place the child with his presumed father, who did not live with his mother. The mother appealed, seeking to have the boy placed with his presumed father without the court entering a removal order. The court rejected this argument as a matter of law, since the applicable statutes make it clear that the court may not place a child with a separated spouse without first making the determination of whether to remove the child from the current custody of his or her mother or father. You have to do the removal first before you can consider the alternative placement. Next, an anti-SLAPP suit in Manufactured Home versus San Diego County. The Ninth Circuit affirmed the district court's dismissal of a defamation action against the county and one of the county supervisors, pursuant to California's anti-SLAPP statute. The allegedly defamatory statements were made by a county supervisor at various public meetings about the way the plaintiff, a real estate investment trust, managed certain residential properties within the county. To continue its action in the face of the anti-SLAPP statute, the plaintiff needed to demonstrate that the complaint was supported by a sufficient prima facie showing of facts to sustain a favorable judgment if the evidence submitted by the plaintiff was credited. The court found that the plaintiff did not meet its burden on the question of whether the statements were false, so the case was dismissed. Last, another governmental liability case. In Valadez Lopez versus United States, the Ninth Circuit considered a lawsuit filed against the United States under the Federal Tort Claims Act, arising out of the failure by local jail officials to provide the plaintiff with his medications for schizophrenia. The plaintiff was being held in a local jail during his immigration-related detention, pursuant to a contract with the federal government. The Federal Tort Claims Act applies only to negligence committed by federal employees, and it does not apply to torts committed by federal contractors, unless the contractor is acting as an agent and the government has the right to control the detailed physical performance of the contractor and supervise its day-to-day operations. There was no evidence the local jail authorities were acting as agents of the federal government, or that the federal government exercised control over the physical performance of their duties. Accordingly, the court dismissed the Federal Tort Claims Act cause of action. The court also dismissed the plaintiff's Section 1983 and Monell claim, which essentially alleged that the Yolo County Public Defender had failed to train his staff about the immigration consequences of pleading no contest to criminal charges. The poorly drafted complaint did not allege that the county public defender had actually trained or supervised the attorney who actually represented the plaintiff. And the complaint did not even allege or mention the fact that it was asserting a Monell lack of training claim. So the court dismissed the cause of action in part because, as drafted, it did not put Yolo County on notice of its theory of liability. It would appear here that the plaintiff was poorly represented both in his criminal case at trial and in his subsequent civil lawsuit at trial. Although on appeal, where the Ninth Circuit had appointed the UC Davis Civil Rights Clinic, it appears he was given good representation. It's just that on appeal it was too late to fix the problems with the case. Well, that's it for today's Kelso Report. Have a great day in the law.